Hello, government students. Today, as we start getting into the real meat of the Constitution, I want us to just look over some processes, especially if you're taking this class from home, and get some definitions for you as well that we'll cover in class. And I want to make sure that you have the same opportunity to get the definitions from home. As we proceed over the next couple of weeks, we're going to be using the Illinois Constitution quite a lot. And I have here a link that you can use to get to the Constitution. If you click on it and it doesn't work, just highlight that link and put it in a web browser, and you should get to the table of contents for the Constitution, where then you can click on the appropriate article that we're studying at the time. So make sure you keep this link handy. You might want to even bookmark this website link in your computer. So let's go ahead and proceed and get to some definitions related to especially the Illinois Bill of Rights. Okay, the Illinois Bill of Rights is Article 1 of the Illinois Constitution. There's a whole lot of rights that are contained in the Illinois Bill of Rights. It's much larger than the Bill of Rights of the United States Constitution. And there's quite a few words that might be archaic to you or just need a little clarification. So that's what we're going to do here. The first word is a word that you've used quite a lot if you grew up here in this country, and that's a warrant. I just want to make sure that it's understood that a warrant is permission that's given by a judge in the court, and that is permission to search someone's home or belongings, or permission to arrest someone and charge them with a crime. Again, in the Constitution, the police do not have the right just to search your things or to come into your home. They must have a warrant in order to do that, and the warrant, again, is a written document that is signed by a judge that grants permission for the police to do those things. Bail. Bail, of course, is money that is paid by someone who has been arrested, and that bail will, once the bail is paid, that person will be able to stay out of jail until a verdict in the trial is reached. We let people pay bail and get out of jail while they're waiting for the verdict in order to help them to prepare their defense. And after all, they've not been found guilty. We are innocent until you are found guilty. So the bail recognizes that fact. You shouldn't be punished and sitting in jail if, in fact, you're innocent of the crime. Now, there are limits to bail, which are in the Bill of Rights. Bail is not necessarily to be allowed for a capital offense being an offense where you could conceivably get the death penalty. So what we're talking about there is murder. If you are charged with murder, you probably will not be able to get bail. Habeas corpus, that is a Latin term for have the body. It's a very archaic medieval Latin term. And it means, though, that you have the right to a court hearing to see the evidence that you committed a crime. What would happen back in the Middle Ages if you were arrested for a crime? The sheriff in England would contact the judge and say, I have habeas corpus. I have the body of the defendant in custody. And at that point, if you are arrested, you have a right to have a court hearing so a judge can determine whether or not the evidence that you have committed this crime is sufficient for you to have been arrested in the first place. It's important that you have the evidence, that you yourself can see this evidence, because this will allow you to prepare your defense. If you don't know why you've been arrested, it's going to be pretty hard for you to defend yourself. There could be a perfectly legitimate reason for you to have done something which could be interpreted as having committed a crime, when in reality you did not. You need to be able to see the evidence so that you can mount your defense. Double jeopardy. Double jeopardy says that if you are found not guilty of a crime, that you can't be charged for that exact same crime again. This is why it's very, very important that if someone is going to be charged for a crime, the police need to be really, really sure that they've got a good case. Because if they do not have a good case and you're found not guilty, and then later evidence comes around that you did in fact commit that crime, you cannot be charged with that crime again. Now, let's make sure this is clear. If you are put on trial for robbing a bank and you are found not guilty, you cannot be put on trial for robbing, for that specific crime of robbing that bank at that time again. However, if you should rob another bank, you can be found guilty. You can be arrested if you're robbing a different bank or robbing the same bank a different time. But you can't be charged twice for the same incident. So that's important to remember. A few more definitions. Excuse me. Corruption of blood. The Illinois Constitution says that there can be no corruption of blood. That's a very archaic term as well, but corruption of blood means that you are punishing a criminal's relatives or descendants for a crime that was committed by the criminal. That's not allowed. So, for example, if I go and rob the bank and steal a bunch of money, and I'm caught in that crime and I'm arrested, they cannot punish my wife for that crime. They can punish me, but not my wife. Now, it's clear, let's make sure we understand this. If I steal a whole bunch of money and I go and buy a $2 million home and with stolen money, well, if I'm caught for that crime, I probably will not be able to keep that home. My wife will not be able to continue living in that $2 million home that was purchased with stolen money. But other than that sort of incident, the relatives or descendants are not allowed to be punished for the crime of one person. Eminent domain is the right of the state to take someone's property for the greater good of society. Eminent domain is allowed in our Constitution. It's usually used to build roads or expand, widen roads, or to create a new park. When eminent domain is used, the property owner must be paid a fair price for the seized property. Even though the property owner must be paid a fair price, typically, eminent domain is a very controversial thing. No one wants to really have their property taken from them, even if it's for the good of society. So the state is very, very hesitant to exercise this power because it does cause a lot of, chaos and turmoil in someone's life when they lose their home or they lose their property. But it is used occasionally, typically for roads or parks, and when it is used, the person who owned the property must be fairly compensated. Ex post facto, another Latin term which means after the fact. An ex post facto law punishes someone for something that they did, and when they did it, it was legal, but now it is illegal. Okay, so for example, let's say I'm driving down Interstate Highway 90 and I'm going 70 miles an hour, which is legal if the speed limit is 70 miles an hour. I'm clocked by the automatic camera going at 70 miles an hour, and let's say next week they lower the speed limit to 60 miles an hour. They cannot give me a ticket for going 70 even though the speed limit is now 60, because when I was going 70 miles an hour, that was legal. So there's no ex post facto laws allowed. If it's legal when you did it and is later made illegal, they cannot charge you for committing a crime because it was legal when you did it. Okay, just a couple of more provisions that I want to make sure you understand. We have in our Constitution the freedom of religion, but there are limits to freedom of religion. And the Constitution and our Bill of Rights for the state of Illinois specifically says that we have freedom of religion, but the liberty of conscience hereby secured shall not be construed to dispense with oaths or affirmations, excuse acts of licentiousness, or justify practices that are inconsistent with the peace or safety of the state. That's a handful of words. So let's put this in modern day English. Your freedom of conscience, your freedom of religion is protected. And your freedom of religion, however, won't be interpreted to do away with the requirement to take an oath or an affirmation of office. So for example, if you are elected to an office in the state of Illinois, you're required to take an oath that you will promise to abide by the Constitution and protect and defend the Constitution of the United States and of the state of Illinois. You cannot use your religion as a way to get out of taking that oath of office. You have to take the oath of office, or at least affirm that you promise to do that. So the freedom of religion is limited in that respect. You still have to make the promise to defend the Constitution. Nor can you use your religion to excuse acts of licentiousness. That's a fancy word which basically means sexual immorality. I couldn't use my religion, for example, as an excuse to do something such as run a house of prostitution. I could say, well, these prostitutes are, free to do what they do because it's within their religious rights. It is an act of religion for them to do what they do. I can't do that. That's going against social norms of proper behavior. So licentiousness means, again, that sexual immorality. Your religion can't be used as an excuse for that. Nor can it be used for anything else that is inconsistent with the peace or safety of the state. So I would interpret that as meaning if my religion says I should go out and slaughter a lamb on the corner of State and Alpine, well, guess what? That's going to be causing trouble, at the busy intersection. I can't go out and slaughter a sacrificial lamb at the corner of State and Alpine. That's inconsistent with the peace and safety of the state. And there are also a few limits to the freedom of speech. And the Constitution and our Bill of Rights does give us the freedom of speech. And it goes on to say, in trials for libel, both civil and criminal, the truth, when published with good motives and for justifiable ends, shall be a sufficient defense. Libel is where you are accused of telling a harmful lie about someone. And in that case, you could end up going to court, to trial. Someone might sue you for lying about them. So what this clause is saying is that if I told the truth, that is a sufficient defense. I cannot be punished for telling the truth. Now it goes on though, and it gives a little bit of a qualification. The truth, as long as I have good motives and justifiable ends, shall be sufficient defense. So let's pretend that I discover my next door neighbor is having an affair with the mailman. Well, I could go ahead and pay for a great big billboard, a big sign on State Street, and say that my neighbor, Jane Doe, is having an affair with the mailman, and put that out on State Street for the whole world to see. I'm telling the truth. If I know 100% that she's having that affair with the mailman, I am telling the truth there. But do I have good motives or justifiable ends in announcing that to the whole world? Obviously, I do not. It's none of my business what she's doing in her private life, and it's no one else's business either, except for her own business, her spouse's business, and the business of the family with whom she's having the affair. So, I don't have good motives or justifiable ends in announcing that to the whole world. In that case, I could be sued, and I would lose that lawsuit because even though I told the truth, I didn't have a good motive. I was not justified in announcing that to everyone. So those are some provisions I think that you need to be aware of in our Bill of Rights. I believe you probably have an assignment in Canvas pertaining to the Illinois Bill of Rights. So go ahead and check Canvas, and we'll talk to you later.